Good morning. Good morning, everybody. This is going to be an online course of the real estate trading services. The real estate trading services course has 26 chapters in all. About 2/3 of the course is law and learning about what realtors, what another name for realtors is reps, what they must do. And 1/3 of it is the real estate math. So what we have here is the first chapter of the real estate trading services course. This first chapter is going to be free for everybody to evaluate and see if they like the material, and then Chapter 1 and Chapter 2 will be free, and Chapter 3 onwards, if you are getting use out of these two chapters, then you can sign up for the other chapters. So let's get started on Chapter 1. Chapter 1 in our course has many topics, but we are going to concentrate on the most important parts that are part of your examination. Okay, and you know your examination is offered by Sauder School of Business. It has 100 questions, multiple choice, and we'll talk more about how to go about getting ready for the examination also. But let's first of all go through the topics that we will be covering. The topics are government, levels of government, types of law, sources of law, civil courts, trial process, enforcement of judgment if the person that lost the case does not pay, mediation, what's mediation versus discovery, CRT, which is called Civil Resolution Tribunal, and do a few practice test questions. So let's get started on the first topic. First topic is levels of government. We have 3 levels of government in Canada: the federal government, provincial government, and the municipal government. The federal government is responsible and owns the federal lands. 2 main topics. They have jurisdictions for many other topics, but for your examination, 2 main topics of the federal government responsibilities are postal and fisheries. Then we have the provincial government. For your examination again, main important part is that they're responsible for our Real Estate Services Act and the education. Okay, and then the provincial government delegates land laws to the municipal government. So the municipal government, which is the city government, which is responsible for the private owned individual lands. So the main thing that we want for our examination from this is that the federal government is responsible for postals and fisheries, and the provincial government is responsible for education and real estate, and the municipal government is responsible for private owned land. And the other thing that we want to know is when we have the governments making laws, they're called statute laws, and how we recognize something is a law, a law is recognized by the word act. So either it'll say Real Estate Services Act or Education Act, Welfare Act. So all of these words which have the word act at the end are either federal government laws or provincial government laws or municipal government laws. So that's the main thing that we need to know for this course and for the examination. Okay, 2 types of law. 2 types of law. One is called private law and the other is called public law. Okay, another name for private law is tort or civil law. Okay, so you need to know for your examination that under private law is basically dealings of person against person or a company versus a company. Okay, so private law or tort or civil law is anything to do with contracts between people or between companies or between a person and a company. Okay, so also private law is about divorces, real estate, negligence, anything to do with negligence, the private law is involved in that, and agency. Okay, so you have to remember that for your exam. Private law, small stuff. Public law is where the federal government or the provincial government is involved in taking care of the public. So whenever there's issues with criminal law, or constitution, or tax, then that is federal government versus another party, and that is called public law. So for your exam, you need to know that there are two types of law. One is called private and the other is called public. Private is the small stuff between people and between a person and a company, and the public is between the government and the person. Third topic. Third topic is sources of law. Okay, we have three sources of law. When a judge has a case that he's hearing, he has three options, three types of law that he could look at. One is called common law. Okay, common law is from hundreds and hundreds of years ago, that when England came to Canada, basically Canada used or started with the laws that came from England, which were called common law. Common law is still being used. Okay, this common law is the oldest. Then, because common law was many times very unfair to the person who lost the case, sometimes a person who lost a case, let's say someone who loses a case of losing, someone steals their dog, and the judge now only had one course of action after he found the guilty person who stole the horse or stole the dog. Even though that dog could be standing right in front of him, the judge had no power to give the innocent party the dog back. It only had power to give what's called damages. Okay, under common law, there's only one thing that the judge could do after he had decided who is the guilty person and who is the innocent person, and that was called damages. Second part, which is called the equitable law, and equitable law came about because common law was very, very rigid. There was only one outcome that the judge could give, and that was money for loss of not having that dog. Even though the dog was sitting in the court, the judge had no power to have the guilty person return the dog to the innocent party. In equitable law, which was developed because of this problem with the common law of only having one remedy, was developed by the kings and the queens of a couple of hundred years ago. Okay, so equitable law is number two, and then because common law was very, very rigid, and again, it only had one remedy, statute law was developed by governments. So statute law is government-made law. Common law is law made by judges. And equitable law came about because common law had only one remedy. And the statute law also came about because there was only one remedy in common law. So both equitable law and statute law came from common law. There are still some situations where the judge can only use the common law because there are no situations or no laws of equitable and statute that the judge can rely on. So let's go through each one. I've given you a little brief introduction to each one, but let's go more depth into each one. And in our examination, usually there's one or two questions from common law, and maybe one or two from equitable law, and maybe one from statute law. So let's go through it. Okay. Common law, if you see the picture here, it's the picture of England. And basically, it came from courts of England. 200 or 300 years ago, common law came. we used Canada, picked up common law because most people came from England and they brought that law with them because there was no law, no other law in Canada at that time. So what you need to remember about 5 things for your examination regarding common law. First is it was law made by the judges, okay? Not government, but judges, okay? Now, when the judges made this law, they needed to make sure that there is some system that they could use. And the system that was used is what's called principle of precedence. That means that whatever has been decided by a previous judge, that will be the source that the judge will use for any case that he has in hand at that now time. Okay, so whatever decision was made by a previous judge, that would be the same decision that would be used by any judge that had the case later on. Okay. Okay, so the word precedence, very important for your exam to remember. It's a previous case or legal decision that is going to be used in the case at hand. Priority, the word priority means what's more important. Let's take a look at another principle called doctrine of stare decisis. Stare decisis, okay? And basically, the concept is that judge will follow a former decision. If he can find an exact similar case, then he will use the outcome of that case as the outcome that he has to make for the case that he has in hand. Okay, so the word stare decisis is a definition that will definitely be on your exam. Basically, it means the former decisions are used to make latter decisions on cases being heard at the time. Okay, what this does is it creates what's called uniformity, meaning consistency. So even the criminals would know that, hey, if I do this crime, this is what's been already outcome by a judge, I will also get the same outcome. Okay. Now, sometimes the case is similar, but not exactly. Then the judge's job is to distinguish. Distinguish means to see if he can find the facts that are very, very crucial, but they're different, slightly different. If the case is slightly different, then he will not use the same outcome. Okay, so if the situation is exactly the same, that is called stare decisis. Then the judge will give the same outcome. If the points are, if the evidence is different, if the case is slightly different, then judge will distinguish if the facts of former case are different or are not present. Then the judge will have to show that, and the judge will make a different decision. And also, sometimes if the judge cannot find a case at all within BC, then he is able to, he's allowed to, he's required to look anywhere in any of the provinces or the Yukon territories or anywhere in the Commonwealth countries. So common law was very, very rigid. And why is it rigid? Is because it only had one type of remedy or reliance. After the judge found one of them to be guilty, the judge only had one remedy that he could put on that one guilty person. And that was what's called damages, which is money that would be given to the innocent person by the guilty person. Even though if the person stole his dog or stole his horse, the horse is still with the horse and the dog will be allowed to stay with the guilty person. And that's why equity law was developed. Continue. Okay, so because of the stare decisis, this is a Latin phrase, okay? Basically it means that former decisions are used as a basis for latter decisions. And because of that, a person who does a crime will know what exactly will be happening to that person, Okay? Judges created uniformity by having the decisions, using the same decisions on the same facts. Okay? So stare decisis, judge will follow the decision of a former case because they are exactly the same facts in the case that he has now, that he's hearing. Okay? And distinguish is opposite, and that is where the judge will not follow the decision of the former case because crucial facts of the former case are not present or are not the same. Okay, so another little clarification of stare decisis and distinguish. If the facts between previous case and case at hand are the same, then the decision by the judge will be the same. If the facts of the previous case and the case at hand are not the same, then the decision by the judge will be not the same, will be different. So let's say we take a look at an example. Let's say a long time ago there was a case where Tom steals a dog. Okay, and now we have another case, let's say in the year 2021, where John steals a dog, but it's to help him through the snow. Okay, let's say in the year 1700, the judge looks at the case and the judge awarded the innocent person $2,000 for his dog, even though the dog is still sitting in the court. And who has the dog? Tom has the dog. Okay, so the judge in 1700s, in the old time, this is using common law, decided this: yes, Tom is guilty, but Tom gets to keep the horse or the dog, but the innocent person will get $2,000. Okay, let's say the similar case is in front of a judge in the year 2021, but if he feels that it's exactly the same, all the facts are the same, then the judge will reward the damages of $2,000. But if the judge feels that the crucial facts are different, then the judge will distinguish the case and the judge can give a different outcome. Maybe he would say that the dog needs to be returned to the owner, and perhaps maybe some damages of the owner who lost the dog for some period of time. So everybody see the difference. Okay, so common law, very rigid. The reason why it's very rigid, the judges found it very rigid because after the judges had decided who was the guilty person and who was the innocent person, there was only one remedy or one result outcome that the judge could give, and that was money. And money was taking the person and putting him back into the situation where he was before. Okay, and damages really are money of inconvenience to the person. The word inconvenience, so it's not really of doing the job. Damages really means inconvenience, how inconvenient the person is put. Okay, so the second type of law, or second source of law, is the equitable law. Equitable law came about a couple of hundred years ago because there was only one outcome that the judge could give to the innocent person. In equitable law, there are three outcomes that the judge could give to the innocent party. Okay, so equitable law, also called courts of equity. Another name for equitable law is courts of chancery. Okay. Developed. Why was equitable law developed? Because equitable law was developed because many results and rules in the common law were strict, rigid, and unfair. Really, it was the result that was unfair many times, because in common law there was only one end result that the judge had, and that was called damages, which is money given to the innocent person. But perhaps the innocent person didn't want money, he wanted his pet back or dog back, or if it was a contract, perhaps the innocent party wanted the person to finish the job, or perhaps the innocent person wanted the person to stop doing the job. Okay, none of those were available for the judge as remedy. So came about equitable law. Okay, so equitable rules, because equity outcomes are more relevant and more recent. We're going to talk about that. That's very important for exam questions. Equity rules will prevail. That means will be preferred by the judge. So if there is an equity law that comes, if there's a case that comes before the judge, and the judge can look at both equitable law and common law, then the judge will look at equitable law because it's more fair and it's more recent. Okay, so equitable law, again, developed because common law, the remedy of the common law, which is only one, which is money given to the innocent party, was very strict and rigid. Okay, now the judge didn't automatically use equitable law if he had a choice. He was given a discretion of the court. Judge had discretion of the court to see which one to use, whether to use equitable or common law. But most of the time he would use equitable because it was a more fair system. Okay, so it wasn't a legal right that everybody got to go to equitable court instead of common law court. It wasn't a legal right. It was a fair right, and then most people did go to the equitable court. Okay, so the equitable law had 3 remedies, whereas the common law only had 1 remedy. After the judge finds one party guilty, in common law, there was only possible to provide or give money, get money from the guilty person to the innocent person. That was common law. But in equitable law, there are 3 remedies available to the judge. One is called specific performance, or the other is called injunction. The third one is called quantum meruit. Okay, and we are going to discuss all 3 of them now. Specific performance. Specific performance is where the judge, usually it's a contract, okay, where the judge can say the contract must be fulfilled by the guilty person. The innocent person wants, let's say the innocent person wants his dog back, that means that the dog must be returned to the innocent party. Okay, basically it's more of contract. In contracts, specific performance means whatever is in the contract, the innocent party wants that done, so the guilty party must, judge will order that the guilty party must fulfill the requirements of the contract. Injunction is sometimes a person, the innocent party wants the guilty party to stop doing something. It could be stop intrusion, or stop going through their property, okay, or stop contract. Maybe there's a situation where the guilty person has started doing the tile work for the innocent party, and they're doing a very bad job, and the innocent party wants the guilty party to stop doing the tile work and perhaps pay for removing all the tiles because they were done in such a bad way. So that is called an injunction. That means stop the person, the guilty person, from doing some activity. And the third one, quantum meruit, is where sometimes it's not mentioned in the contract that how much money, and this is all about money, how much money should be given by the guilty person to the innocent person. Okay, so the judge will decide, if it's not written in the contract, or maybe the contract's only halfway through, the judge will decide whatever is fair. And the quantum meruit, again for your exam, is to know that this is a Latin phrase, Latin word, for as much as is deserved, meaning the judge will give to the innocent party as much as is deserved. Okay, so the guilty party, perhaps he's only halfway through the contract and he's done a good job, he feels it's a good job, but the innocent party just doesn't want him to continue. Then the judge will decide, look, the guilty person has done half of the job, he's bought so many supplies, and the judge will be able to make a decision as to how much is owing to the party. Okay, so sources of law, the last one, is called statute law. Statute law was developed by the governments, either provincial government or municipal government, or by the federal government. Okay, all we know anything that's called a statute law has the word act, A-C-T, as the last word of that law. Okay, and it's made, statute law is made and developed from common law. Whichever common law the government feels is not doing the job of today, they will change the common law, and that will be the statute law. And the judge now will follow the statute law as the main source of the judge deciding how to result the outcome of a case. The judge always looks at to see if there's a statute law before he looks at equitable law, and the last thing he'll look at, if there is nothing in the statute law and if there's nothing in the equitable law, he will look at common law. So it's the reverse of the way we studied this chapter. In this chapter, we started with understanding what is common law. Then, because common law was very strict, only one remedy, then came equitable law. Okay. Now, because common law again was very strict and sometimes very unfair, came statute law. Okay. Be very careful. From equitable law did not come statute law. Statute law came from common law to change some things in common law, because common law only had one remedy. Statute law, governments could make as many remedies as they wanted, or any remedy connecting to any type of wrongdoing by a person. Okay, so let's take a look at, really it's the remedies of the three laws. Okay, the remedy for common law was what's called damages. It's money, and it's not money for finishing a work, it's money for inconvenience. So if a person in the old days stole a horse or stole a dog, the innocent party would get money for the horse or the dog, even though the dog or the horse is sitting right in that court. The equitable law came about because of only having one remedy in common law. That's why equitable law was developed. And equitable law was developed by kings and queens, and it had three remedies. One was called specific performance, the second one is called injunction, and the third one is called quantum meruit. And specific performance is do what the innocent party wants to be done. Maybe he wants his dog back or horse back, or maybe he wants the person to finish the job. Injunction is sort of opposite of specific performance. It's asking, the innocent party is asking for the guilty person not to do something, either stop the work or not intrude or not cut through his yard. And the third one was called quantum meruit. That's where the judge decides how much money would be given from the guilty party to the innocent party for part of the work being done, or when perhaps they didn't mention how much work, how much money would be owing for this job, for a particular job. Statute law, remedies available for statute law are everything from money, specific performance, injunction, quantum merit, jail time, prison time, all of the above are available by the government. The government would make the law, and the government afterwards would say what would be the remedies for the judge to decide on this case. So let's say we take a look at someone steals someone's dog. If it's statute law, perhaps in the statute law, maybe there might even be a bit of jail term involved in this. Obviously, there would be, a judge would have possibly a jail time and possibly return of the dog to the innocent party, and maybe even payment by the guilty party to the innocent party. So he could have 2 or 3 things all together, not just picking one item. Thank you. Okay, let's take a look at an example again. Example where Tom steals Oscar's dog. So the remedies, okay, in statute law, okay, could be jail, could be fine, could be money, could be return of the dog, okay. In equity law, specific performance would be do what Oscar wants. Probably the Oscar wants his dog back, so he'll get his dog back, and maybe Oscar also wants $1,000 because now he didn't have his dog for a couple of weeks. Okay, injunction, he may also want stop stealing any further, anything, not just his dog but other things. Okay, quantum merit, maybe the judge may be able to say, look, because of this loss, you deserve this much money. But quantum merit is more specifically set aside for part of the work, and when nothing is written, it's more contract in terms of work, okay, not really in terms of stealing. Okay, in common law in the old days, basically the guilty person would be made to provide some money to the innocent party, and judge had no power to enforce the return of the dog. Okay, let's take a look at a car accident. In a car accident, we have Tom runs over Oscar's dog. Tom is the person, he runs over Oscar's dog. Okay, so let's say the judge clearly finds, yes, Tom did run over Oscar's dog. And now if it was statute law, maybe there will be jail, maybe there will be fine, maybe there will be money that the judge will award to the innocent Oscar. Okay, in equity law, okay, obviously the Oscar isn't going to be wanting the dead dog back. Okay, he would maybe he does want the dead dog to do a funeral, so he would be given back the dead dog. Okay, also injunction, meaning stop running over any of his dogs or any pets. Okay, quantum merit, probably no money like that. Okay, in common law, again, money from Tom to Oscar, and money would be how much the dog is worth, not just in value of the dog, but how much inconvenience Oscar has been put because of losing his dog. Okay, let's take a look at a contract where we have Harry. He's the homeowner. He hired Charlie to do some tile work. Harry now, the homeowner, fires Charlie because he's not happy with the work that Harry is doing. Okay, let's say if the judge finds that the contractor is in the right, Harry is just too fussy and maybe doesn't want to pay him. Okay, and if the judge says, hey, judge, I feel, or a judge feels that the contractor has done everything, he's not doing a bad job, it's just Harry that's being too finicky and too picky, well, according to statute law, there would be money compensation to Charlie in dollars for all his losses, for all his time. Okay. If it was equity law, basically the person wants to also end the contract, he would end the contract. Injunction, possibly none. Quantum merit now. Who's going to get paid? Well, the contractor wants to get paid, and perhaps it's not written in the contract how much work is done. If it's part of it done, how much would be owing. That would be the judge's decision to make how much, as much as is deserved. Remember, quantum merit means as much as is deserved. Okay, and in common law, basically it'll be again money, dollars, for inconvenience and work done by the contractor. Now, in the same situation, if the judge feels that the homeowner is in the right, if the homeowner is in the right, then compensation, according to statute law, money for and stop of the work, okay, stop of the contractor, compensation to homeowner to replace all the tile work, maybe it's not to anyone's satisfaction, okay. Equity law, end of contract, injunction, stop working, and again, quantum merit, homeowner is given monies to replace all the tile work, okay, clean up, and in common law, compensation, damages to the homeowner to remove the tiles and all the inconvenience. Okay, so let's do a review. 3 sources of law: common law, equitable law, statute law. Okay, a judge will first see if there's a statute law that has been passed that will provide the solution to the conflict. If no statute law exists, then the judge will look to equitable law and then common law. Okay, this is priority. This is called prevail, which will prevail. Your exam questions will say, if no statute law exists, what will prevail? Well, it'll be equitable before the common. A judge may apply both common and equitable in deciding. A judge has no favoritism of which law is fair, which is unfair, because these laws are made already by the government or by common law previous judges. So the judge's decision of the previous is all finals, and statute laws are all finals. So priority for the judges, it's the opposite. It's not common, equitable, statute. It's statute first, and then equitable, then common law. Memorize the word SEC. If you memorize the word SEC, S stands for statute, E for equitable, and C for common. All your exam questions you will be able to answer because the order or the priority is S for statute, E for equity, and C for common. So when a case comes before a judge, he'll look at statute first, equity second, common third. So in a conflict, exam type of question, in a conflict between statute law and equitable law, well, let's take a look at SEC. When you do the exam, put the word SEC beside you. You know statute before equity. So statute will prevail. Statute will be preferred. Statute law and common. Statute and common. Statute will prevail, will be preferred. Equitable and common. Equitable and common. Equity will be preferred. Next topic is topic number 4, civil courts of British Columbia and Canada. Okay, and the examination questions for civil courts, maybe 1 or 2. Very, very important that you know the court system, and as a realtor, it's important that you know the court system, Okay, the court system, basically we have 4 courts in British Columbia and Canada. The first 3 are British Columbia, Small Claims, BC Supreme Court, and the BC Court of Appeal. Now, if the case does not get resolved within these 3 courts, then the case may go as an appeal to the Supreme Court of Canada. These last 2 courts here, in my opinion, this should have also had a name with the word appeal in it. Then we would know that these 2 courts are appeal courts, okay? So any case that you have will start either in small claims or a BC Supreme Court, okay? Small claims are easier to work with. Usually you do not require lawyers. In the BC Supreme Court, most judges will ask the parties to have legal representation, meaning have lawyers. So now most people will start their case, or most people will take their case to what's called small claims courts, okay? There are about 6 or 7 different cities with each having small claims court. Within Lower Mainland, we know Vancouver, Surrey, Richmond, New Westminster, they all have small claims court. So you could take your case to any one of those cities. But we're going to talk about, there are some restrictions as to which city you can take the case to. In BC Supreme Court, if you wanted to start your case there, you're welcome to start there. There are no restrictions, any other territory or money, okay? You cannot take your case to BC Court of Appeal. It is an appeal from here to here. You cannot take your case to Supreme Court of Canada because it also is an appeal court. It's an appeal from here to here. Let's take a look at each one, and then we will go explain or clarify the appeal process and how that works. So let's take a look at first the small claims court. Okay, small claims court. It's the lowest trial court in BC. Okay, you notice the difference in your exam questions. Yes, you really need to know the terminology. BC Supreme Court, here's BC Supreme, remember there's 4 of them. There's the small claims, BC Supreme, BC Court of Appeal, and Supreme Court of Canada. There's 4 of them. We're looking at the first 2, okay? The first one, small claims court, the lowest trial court in BC. This is not a appeal court, okay? This is where you can start your case, okay? Only one judge, same thing here, only one judge, okay? Appeals from the small claims go to this court, BC Supreme Court. And there is a limit. If you're suing someone for more than $35,000, then you have to start here, because here there is no limit, money limit. But if the case is if you are suing someone for more than 35, but because you don't want to spend the money going to BC Supreme Court, you may take up only 35, then you are allowed to go to this court. The other thing is what's called a territory restriction. Territory restriction prevents the plaintiff from abusing the system. The territory restriction says that the plaintiff who's going to sue or take the case, and the defendant is going to defend the case, it's all on where the defendant lives, or where the defendant has business, or where the accident happened. It's nothing to do with plaintiff. Plaintiff is, yes, going to take the case. He's going to do the suing. But it's where the defendant lives and the defendant has business, or where the accident happened is where this case can start. Okay. Let's take a look at BC Supreme Court. One judge. This is called the highest trial court. Well, is there a higher court? Yes, there is in BC. It is called the BC Court of Appeal, but it's not a trial court. This is only a appeal court. But one thing very, very interesting, and for your exam, the BC Supreme Court is a trial court and also a appeal court. Okay, it's also an appeal court because an appeal from small claims, if the person, the guilty person, the judge finds someone guilty, if that person is not happy with the outcome, okay, or if the innocent party is not happy with the outcome, they can appeal, and the appeal will go to the BC Supreme Court. Another thing about the appeal that comes from the small claims to BC Supreme Court is that the judge can decide either he's going to treat this as an appeal or treat this as a brand new case. If he treats it as an appeal, then evidence is not reheard. Both the plaintiff and the defendant do not need to be even in the court. Only their lawyers perhaps, and only all the documents that were already presented in the small claims, the judge will look at them and make a decision. Or the judge may say, I'm going to award a brand new case, a brand new situation, or a brand new case, okay? And that means everybody has to come back to court. All the witnesses and all the documents have to be presented again. So the judge has a choice whether to treat the case from here that is appeal to here to be an appeal or a brand new case. If it's a brand new case that started here, obviously all the evidence will be heard, not reheard, will be heard, and the judge will make the decision. Okay. Okay, so a definition that you need to know for further clarification: a plaintiff is a person who brings the case, and the defendant is the person or the company. In this situation, it could also be a company that's being sued that will defend the situation. So here there are no money limits, meaning a person could sue for millions of dollars, anything more than, even less than 35. If someone wants to sue for less than 35, they have a choice. They can go here or here. There's no territory restriction, meaning the plaintiff can take the case anywhere he wants. He can start the case anywhere he wants. Of all the 10 or 11 jurisdictions of courts, cities that we have, the plaintiff can take the case anywhere he has if he wants the case to start in BC Supreme Court. Okay, so now we're going to look at the BC Court of Appeal and Supreme Court of Canada. We looked at the first two, small claims and BC Supreme Court. Small claims, remember, it's the lowest trial court. This is called the highest trial court, but really this is a trial court and a appeal court. This is only an appeal court, so it's really the highest court in BC. This is the highest court, trial court in BC. This is the highest court in BC. This is the highest court in Canada, even though it's only a trial court, appeal court. Okay, so let's take a look at BC Court of Appeal, number 3. Highest, it's called the highest appeal court. Okay, another word that's used for appeal is appellate. Okay, be careful in the examinations, they'll use either the word appeal or appellate. Appellate means, it's a big fancy word for appeal. Okay, appeals to BC Court of Appeal, this number 3, come from BC Supreme Court. Okay, let's say there was a situation where a case started in small claims, they appealed to BC Supreme Court, and they're still not happy, they can take that case to BC Court of Appeal. And if they're still not happy, they can take that case to Supreme Court of Canada. Okay, cases don't go to number 3 and 4 directly. Cases either go to number 1 or number 2. And then it's appeals. Appeal from small claims is to BC Supreme. And if it's an appeal or a brand new case and people are not happy, then the appeal goes to BC's Court of Appeal. And again, if they're not happy with the result, innocent party or the guilty party not happy with the results of the judge, then they appeal to the Supreme Court of Canada. Okay, so in number 3, this is where we are, BC Court of Appeal. Evidence is never reheard. Evidence is whatever evidence was presented in the court, either small claims or BC Supreme Court, it will not be reheard. The judge basically has all the documents, all the paperwork, and he will look at to see if the legal principles applied by previous judges, and he will review them. Okay, will hear all appeals. Okay, it's an automatic. If you want to appeal from BC Supreme to BC Court of Appeal, you're allowed. Any party is allowed. Every party is allowed to appeal, and the BC Court of Appeal must hear the case. Well, not hear the case, but take the appeal and look at the situation, not evidence going to be reheard. Evidence, obviously look at evidence, but not rehear the evidence. Okay, obviously decisions can be reversed. In BC Court of Appeal, remember in small claims and BC Supreme, there was only one judge. In this one, there could be 3 or 5 or 7. Okay, for your exam, you see a 9 here. It's possible there could be up to 9 judges in Supreme Court of Canada. Okay, now let's take a look at Supreme Court of Canada. It's the highest appeal court in Canada. Notice the difference. This is highest appeal court in BC. This is the highest appeal court in Canada. Appeals from BC Court of Appeal. So from here, if people are not happy, that's where the Supreme Court of Canada is where the appeal goes. Okay. Again, only legal principles. Evidence is not reheard. Okay. Only legal principles applied by previous judges are reviewed. Okay. This is very important for your examination. It's not an automatic that an appeal from here will be allowed. The judge or judges will decide whether an appeal from BC Court of Appeal will be allowed to the Supreme Court of Canada. Remember, we said if someone wants to appeal from here to here, automatic, allowed. If someone wants to appeal from here to here, allowed. But if someone wants to appeal from here to here, it is up to the judges to allow or not allow the appeal. Because sometimes people just have money and they're wasting the court's time. Okay, so not required to hear all appeals. Again, decisions may be reversed. Okay, let's take a look at a situation where a car accident happens and Tom, the defendant, lives and works in Kamloops. Okay, Tom is being sued that he ran over Oscar's dog, and it happened in Prince George. So where does Tom live? Tom lives and works in Kamloops, and Oscar's dog was run over in Prince George. Now Oscar is called the plaintiff. Okay, Oscar is going to start the case, and Oscar lives in Victoria and works in Vancouver. Territory restriction. Plaintiff can only take the case to court where defendant lives or defendant has business or the accident happened. So let's take a look. Kamloops, yes, allowed. Prince George, allowed. Victoria, no, because Victoria is where the plaintiff lives. Vancouver, not allowed. Vancouver is where the plaintiff lives. So for your examination, you need to know plaintiff is the person taking the case to court. It's decided by defendant's territory, where he lives, where the defendant lives or defendant has business, or where the accident happened. Okay. So let's take a look at the order. Okay. Civil courts, we know there's small claims, there's BC Supreme Court, there's BC Court of Appeal, and Supreme Court of Canada. You can start your case in small claims, or you can start your case in BC Supreme Court. Okay. If you wanted to start your case in small claims, if the plaintiff wanted to start his case in the small claims, he has to the case has to be less than or equal to $35,000, and the plaintiff can only take the case where the defendant lives or where the defendant has business or where the accident happened. If the plaintiff wants to take the case to BC Supreme Court, there are no restrictions of money. There are no restrictions of where the defendant lives or the plaintiff live. Okay, so the plaintiff has a choice of either taking the case to small claims or BC Supreme Court. Okay, if the plaintiff is not happy or the defendant is not happy with the decision of the small claims, let's say he started his case there, then he can appeal to the BC Supreme Court. Now the judge, if that case comes in front of the judge in the BC Supreme Court, may treat this as an appeal or may treat this as a brand new case. If the judge treats it as an appeal, then evidence will not be reheard. If the judge treats this as a new case, then all evidence must be presented by both the plaintiff and the defendant. If the person or one of the parties is still not happy from the appeal that they did in the BC Supreme Court, okay, let's say they started the case in small claims, they took it to BC Supreme Court as appeal, and the judge, they're not happy with the judge's decision, then they can appeal to BC Court of Appeal. And at the BC Court of Appeal, it will only be an appeal. Evidence will not be reheard. Only the judge will look at all the documents and then give his decision. If the parties are still not happy, or one of the parties is still not happy, then it could be appealed to the Supreme Court of Canada, and the Supreme Court of Canada may reject the appeal, saying we will not accept this appeal. You have to take the decision of the judge from the BC Court of Appeal. Great. Okay, another topic we're going to talk about is what's called the trial process. Okay, so it could start in BC, it could start in small claims, it could start in BC Court, BC Supreme Court. That's the only places where a trial can start or happen. The other two, BC Court of Appeal and Supreme Court of Canada, trials do not happen there. They are only appeal courts. And appeal courts, the people, the plaintiff and the witness, plaintiff and the defendant do not even show up in the court. It is only the judges that look at the documents. Okay, so in reality, the trial process is really pleadings, discovery, trial, and the judgment. Okay, first part here, I listed it out for you. Action. Action is where something wrong happened. Really, in my opinion, the trial process should be including the action. If there is no action, if nothing wrong happens, none of this will happen. But for your examination, the first part of the trial process is called the pleading. Then discovery. And discovery, we're going to talk about that discovery is really a mini trial, but it's not really a trial either. It's just without a judge and under oath, both parties perhaps lawyers have to bring all their documents and present everything to each side. It's not something that a surprise will happen and show up in a trial. All the material that was presented under oath in discovery is the only material that will come up in the trial, if it ever does, if it continues to be a trial. A lot of times things are decided in the discovery because both parties get to see each other's documents and their defenses. So everything's given out without judge being there. And maybe sometimes, most of the time, not maybe sometimes, but most of the time, one of the parties, either the defense or the plaintiff, says this case is too weak and I'm not taking it forward myself. Okay? Or he might decide that the case is very strong. He will take it to trial. Okay? An example would be, let's say it's the stealing of the dog. Okay? And if the plaintiff has a video or has taken pictures of the dog being stolen by the defendant, obviously the defendant will not want to take this case to a trial, because now the trial will be very expensive. And if the evidence is already there that there's a picture or a video of the defendant taking the dog, the plaintiff is going to win the case. And if it goes to trial, the judge may even award costs. The word costs means maybe the plaintiff's lawyer expenses will also be coming out of the defendant. Not only returning the dog and maybe fine, maybe jail for the defendant, because there's a good evidence that the plaintiff has of his dog being stolen, that now the judge will say, you saw that in the discovery, why did you not make a decision or work out a solution in the discovery? You wasted the court's time, and because of that, court costs are going to be given so that the defendant has to give the court costs. And the last part is what the judge does, and he calls and brings about a judgment. He decides who's guilty, who's innocent. Okay, let's continue. A few things that we need to know. What's a plaintiff and what's a defendant? We've talked about that. Plaintiff is the person who's hurt, who brings the case, okay? And it's his job to prove the case, because he's starting the case, and the Latin is burden of proof. Burden of proof means the plaintiff must prove the case. The defendant does not have to say anything in court. It is up to the plaintiff to prove to the judge or jury that this is what happened. Okay, defendant is the accused of the wrongdoing. Okay, and when a case has been decided by the judge, let's say there's money involved, the loser of the case is called judgment debtor, and the winner of the case is called judgment creditor. Really, we're talking about money. Okay, so judgment creditor will get money from the judgment debtor. If the judgment debtor does not pay, let's say the judge has decided, for the dog there's a couple of $2,000, or there's tile work that hasn't been finished, but the judge has decided that the loser has to pay $5,000 or X dollars. And if the judgment debtor does not pay, then the judgment creditor will go back to court and ask the judge to ask judgment debtor to come to court and bring his documents of how much income he makes, what job he has, whether he has a home or not, and then the judge will decide to put another order, perhaps garnishing, perhaps seize of assets, perhaps sale of the debtor's land. So if the judgment debtor does not pay, the judgment creditor has to go back to court, and then we're going to talk a little bit more about that later. Okay, so again, if we take a look at our trial process, okay, action is something that happens, okay. Pleading is the first, discovery, trial, and the last part is called the judgment, where the judge makes a decision. Okay, so action, the first part, is where something goes wrong, something gets stolen, or a contract dispute. Okay, pleading, for your exam, very important. Pleading is really where the paperwork takes place. Okay, plaintiff is a person who's going to start up the case. Okay, he files notice of civil claim, and then he serves the notice of civil claim to the defendant. Okay, two things are happening. He goes to court, files the notice of civil claim, and the courts will stamp it, and then the plaintiff will serve, meaning get it delivered, maybe mailed, maybe hand delivered, maybe a sheriff will deliver for him. That document or that claim will be delivered to the defendant. Then what does the defendant do? Defendant files a response to this claim. Okay, files and serves the response to the claim. So those are 2 steps here, 2 steps here. Very important for your exam. Okay, what's discovery? Discovery and the trial. Okay, so the discovery is a mini trial, but really it isn't not a trial, because really a trial is something which we would say is with a judge. Okay, there is no judge in the discovery. It is in an office. It is the plaintiff and the defendant, and it could be the plaintiff and defendant's lawyers. Okay, basically it's required before a trial happens. It's part of the BC government law that a discovery must happen. And in the discovery, you are required under oath to present your evidence, both the plaintiff and the defendant must provide all their evidence in the discovery. Okay, it's called a mini trial, but it is not a trial. Okay, it takes place before the trial. There could be many discoveries. It's not just one discovery. It could be a couple of discoveries that could be happening before the real trial. Okay, discovery of documents is where both parties bring documents. Okay, most claims are settled after the discovery, out of court. This is the court. This is not really a court. Okay, so they're settled after the discovery because both parties will be able to see the strengths and weaknesses of evidence. Whoever is weak, they will probably say, let's settle this. Whoever is strong may not say anything, but he will also want to settle. Okay, he may not want to settle. He may say, okay, let's go to trial. But the person whose evidence is weak, and the example we gave is if a person ran over someone's dog and someone has a video of that, well, the person who ran over the dog, if there's already a video of that, he's going to want to resolve and say, I don't need to, and I don't want to go to trial. Let's make a resolution here. Let's resolve this. How can we resolve it? There's no judge. Judge is not going to interfere, or is not going to be there. He's not there. Okay. If it does go to court, if it does go to the trial, okay, the process is called the adversarial process. Adversarial process means that we have 4 steps here. First step is where the plaintiff, and remember it's the plaintiff's job to prove, it's the burden of proof is on the plaintiff to prove that whatever he's claiming is providing proof of that. Okay, providing the case. It's his job to prove that that happened. Okay, so plaintiff first presents his evidence, and then he presents his witnesses to that evidence, if he has any. Okay, then the defendant can cross-examine the plaintiff and the plaintiff's witnesses. Step 2 is where the defendant now presents his defense, and if he has witnesses, he can present his witnesses. Then the plaintiff gets to cross-examine the defendant, and if there are any defendant's witnesses, he gets to cross-examine them. On your exam, they have conflicted this by saying, is it defendant goes first, or is it plaintiff goes first? Well, it's obviously the plaintiff going first. Okay. Step 3, judge and jury or jury hear the evidence. And then step 4 is the judge reviews the evidence and gives the decision, which is called the judgment. Okay, so this is up to step 3 is really the trial, and step 4 is our next step here, which is the judgment. Okay, the judgment. Go back. Okay, in the judgment, really the judgment is the order made by the court. Okay, judge issues a decision, and now we already decided that, or not decided, but looked at that the judgment person who wins the case is called the judgment creditor, and we're talking about money now, okay? And the loser of this case is called the judgment debitor. So the trial has finished. First step is the pleadings, that's the paperwork. Discovery is called a mini trial, but really it isn't a trial. Okay, it's where both parties must bring their documents and bring their evidence, and they must share all that evidence. Okay, many cases are resolved in the discovery. They do not go to trial. If they do go to trial, okay, then the burden of proof, or the proof, must be supplied by the plaintiff. And the trial has the steps, step 1, 2, and 3. Step 1 is where plaintiff and his witnesses present the case, and then the defendant gets to cross-examine both the plaintiff and his witnesses. Then the defendant gets to present his defense, and then the plaintiff gets to cross-examine. Okay, enforcement of a judgment. That is where, if the judgment debtor does not pay, let's say the judge says, the loser, please, you must pay to the winner of the case $2,000 for running over his dog or stealing his dog, and or tile work has not been finished, but judgment debtor must pay judgment creditor $5,000, and the judgment debtor has not paid. Well, he's not allowed to not pay. He must pay. So judgment creditor has to go back to court. Okay? He cannot start garnishing his wages. He cannot go to his judgment creditor cannot go to the judgment debtor's boss and say, give me his money. Or he cannot go to his bank and say, give me his money. Or he cannot go to his house and I want to sell your house. It all happens with the court order doing exactly what will happen. Okay, so winner of the case, called the judgment creditor. If loser pays to the winner, all is good, finished. But if no payment is made, then the winner must go back to court. The judgment creditor must go back to court to show that the judgment debtor has not made the payments. Then judgment debtor will be required by court to come to court and bring his assets and income verifications. Then the judge and or the judgment creditor will review the assets and incomes of the judgment debtor. This step here is called examination of judgment. Okay, this is your first step in enforcement of judgment. This will always happen. There's no way for the judge or the winner of the case to know what are the assets belonging to the loser, what are the incomes of the loser, whether he has a home. All this will be found through the examination of the judgment. So that's called examination of judgment debtor. That's where the judgment debtor will bring his income verifications, his job, where he works, how much money he makes, how much property he has, how much assets he has, does he have a car, does he have a house, does he have a cottage, all that. He cannot leave anything out. And this is under oath. If he lies, if the judgment debtor lies, then there may be fines and or penalties or jail time. Then there's these three. It's either one of these three. The judge will decide which of the three is going to be applied to the judgment debtor. Okay, this is automatic. Examination must happen in order to determine the amount that the judgment debtor has, and his job, and his house, and so on. Then it's either examination plus the writ of execution, examination plus the garnishing order, or examination plus the sale of the land. Okay, so again, clarify, this will always be one step. So it's either this and this, or this and this, or this and this. Okay, it's not, this will not do everything. This will only inform the judge and the judgment creditor what the debtor has. How to get the money owing is going to be one of these three. Okay, so if it's the first one, if it's going to be the first one, what the first one means is that the order will be given to the judgment creditor to take the order to the sheriff. And let's say he has a car, let's say judgment debtor has a car, then the order will be for the sheriff to take the judgment debtor's car, sell it, then the money from the sale goes to the court, and then the court will pay the judgment creditor. You notice the way it's not, the money doesn't come directly to the judgment creditor. It goes through the court, then the judgment creditor. So that's called writ of execution. Sometimes just the word execution is used. Okay. Number two, what's number two about? So a judge could say, yes, let's say there's $5,000 owing, and the person has a car worth about $10,000 or $8,000. Yes, let's sell this car and give the judgment creditor the $5,000. Fine. Maybe he has a job, or there's money in his bank account. Okay, then he probably won't force the sale of his car because maybe he needs the car to get to work. So the second one is garnishing. Garnishing, okay, that's where two possibilities are available to the judge. Garnishing of his wages or garnishing of his savings. Okay, garnishing of the wages is if the judgment debtor has a good job, then the maximum amount that could be taken is 30% of the wages. Could be less, but no more than 30% of the wages can be taken. Okay, this order, the judgment creditor takes it to the employer, to the judgment debtor's employer, and the employer is required to take what amount the order says. If it says 20%, then the employer must take 20% out. And the employer will deliver this money to the court, and the court then will give it to the judgment creditor. Let's say his job is fine, but the judge feels there's $5,000 in his savings and the total amount owing is $5,000. Let's just finish this by sending the order. Judgment debtor will send this order, take it to the bank, and the bank is required to take the money, give it to the court, and then the court will give it to the judgment creditor. So that's number two. That's possible. Again, really we have a number one there. Okay, A, it could be A and then 1, or A and 2, or A and 3. So let's take a look at number 3. Number 3 will only happen if it's large amounts of money owing by judgment debtor, perhaps 50,000 or 100,000. Let's say judgment debtor owes 100,000. Taking the 100,000, it's going to take a long time from taking it from his job. Or if he has only 5,000 in the savings, then that 5,000 is only a little bit towards that 100,000. Then the best way for the judgment to happen is through the sale of the land or the home. Okay, so we're looking at number 3 now. So for larger amounts of money owing, order can be made so the sale of his personal home is made. So the judge says, have this order, where the order is the house must be sold to pay off the judgment debtor. Then basically house gets sold, money from the sale goes to the court, and then the court gives it to the judgment creditor. Now, what the judgment creditor does is put a charge on that home at the land title office. Otherwise, this home could quickly be sold by the judgment debtor, and then there's no money to be had by the judgment creditor. So what the charge does is it doesn't stop the sale. It stops it. It makes it so that if there is a sale, that the money will be quickly paid, or paid before all the money is given to the judgment creditor. Before the judgment creditor keeps all of the money from the sale. If there is no charge of money owing by the judgment debtor on that property, then that property could be sold and the judgment creditor could keep all of the money. So when there's an order, and usually when there's an order, first thing that the judgment debtor will do is put a charge on that property. So if it is sold, and which he wants it sold, then the money will come to, part of the money, whatever money is owing to the judgment debtor, he will get it. Okay, so here's a big review. So judgment creditor is the winner, judgment debtor is the loser. Okay, first thing that happens is called an examination of judgment debtor. That's where the judge and the judgment creditor goes through and asks questions about how much money they have, what properties they have, what are their wages, where they work, and so on. Then the judge decides whether to go with examination plus the writ of execution, or obviously the examination has already happened, so it's going to be examination plus the writ of execution, examination plus the garnishing order, or examination plus the sale of land. So it's one of those three. Okay, very important to know that the order is money is not given to the judgment creditor from the sheriff or the employer or the bank, okay, or the sale of the property. All of this money, these people are required to give to the court, and then the court will give to the creditor. And here is something I want you to remember for your exam. It's E plus E. That means execution plus the execution. Here, let's go to the next one. Here. Okay, so it's the examination plus the execution. That's E plus E. See, E plus E. Or E plus G, examination plus the garnishing. Or E plus J. So put this down in your notes because there's exam questions about this kind of stuff. Okay, next topic we want to look at is the difference between mediation and discovery. We know discovery happens before the trial. And we know in discovery there's no judge, it's under oath, and we know in discovery most claims are settled after the discovery because both parties get to see each other's evidence and who has the stronger case. Usually the person who has the weaker case will ask to resolve at the discovery. Okay? Mediation is where one of the parties wants have it resolved. Okay? And that's where they deliver one of the parties, either party, okay? This could happen before the discovery, okay? Or even between the discovery and the trial. That's where one of the parties, okay, starts and delivers to the dispute resolution office to start mediation, okay? One of the parties wants to resolve it, okay? Other parties must reply. Again, there's no lawyers here. Okay, courts are too busy. Our small claims court, usually 3 months, 4 months before your case will be heard. BC Supreme Court, probably a year or 2 years before the case will be heard. So the alternative is something called the Civil Resolution Tribunal, CRT, Civil Resolution Tribunal, okay? It's created to relieve the court's time. Courts are too busy, okay? The fee to start your case at the CRT is very minimal. $50 to $100 or so. Okay, it's online, so that means you don't need to be running around in the BC courts. Okay, all your case can be heard online from your home or your office. Okay, it's there to settle disputes. And what kind of disputes can the CRT resolve? Small claims up to 50,000. Remember, small claims normally are in the court. Small claims court is only 35. So if you have something around 45 or 48,000, you would have to go to BC Supreme Court. Well, you don't have to. If you want to take your case to CRT, Civil Resolution Tribunal, you can do it, and it's online. Both parties will be there, and these CRT has three stages, three phases. First phase is where both parties, sort of like a discovery, both parties give their evidence online, and one of the parties says, let's resolve it and finish this thing at that time. So there's no judge, there's no person making a decision in phase one. So phase one is communication of both parties to settle the dispute. If they can settle it by themselves, and there will be a staff assisting, but really it's both parties communicating and resolving. Okay, if it does not get, if case may end at stage one. You notice it says three potential phases. Okay, it could finish at phase one. Okay, it may not go to phase two. If it gets resolved in phase one, done. Phase two, if it goes to phase two is called facilitation. This is face-to-face now. This isn't online now. First step, phase one, called negotiation, was online. Phase two, if it goes to phase two, it's face-to-face, it's not online. Now, here we get the assistance from the CRT staff in resolving the dispute. They help, they provide assistance, clarifications of some things, and then they help out both parties to clarify their communication. Maybe at stage two, it can be resolved. And there's no judge, there's no adjudicator, there's nobody making the decision. It's both parties decide and resolve the issue. If it doesn't get resolved in stage two, then it will go to stage three. Okay, it'll go to stage three. And stage three is called adjudication. And it's again face-to-face. Okay, adjudicator makes the decision. Now, it's like a judge. He's called an adjudicator. It's a person assigned by the Civil Resolution Tribunal to make the decisions. And these decisions, just like being in the court by the judge, these decisions are enforceable by the courts. Very similar to enforcement of the judgment. Same things can happen here. Okay, so just clarify limits. Small claims 50,000, motor vehicles 50,000, and all strata disputes. All strata disputes can be handled by the Civil Resolution Tribunal. And that is the finished of our chapter 1. And remember, chapter 1 is got 9 topics. And we'll take a look at the last topic, which is practice of some test questions. And I hope you will enjoy this video. Go through it as many times as you like. More times you go through it, the more items you will pick up. And we also have for you a printout of a study sheet for chapter 1. And also we have the exam questions or the practice questions also as a Word documents that you can print out. Okay, we're going to do some practice questions. These are questions of very similar will be showing up on your exam. Your real estate exam is 100 questions, and I believe it's 3 hours. Maybe about 20% of it is mathematics, and my specialty is mathematics, so make sure you go through our videos on mathematics. The 100 questions that you will have, the only way to study them, or the only way to get good at doing the exam questions is actually doing the questions, but really do not start memorizing questions. The same question I'm going to show you can be reworded to ask for the opposite. So always just understand and learn instead of memorize questions. So let's take a look at a question 1. Which of the following falls within public law? Okay, this is a question which is, they usually put in the questions of fill in the blank, okay? And sometimes the question is just which statement is true or which statement is false, and then there's which statements are true and which statements are false. These are the type of questions that are on your exam. I will be making another video of just exam taking and exam skills. So if we look at, remember what public law was, okay? If you go back to your notes in one of the slides where we had private law and public law, we said that the private is small stuff between people and companies. Public is between government, or another word for government is state, and people and companies, okay? So the big stuff, public, we want to know which one's public. So public contracts, not public. Constitutional law, public. Divorce, not public. Taxes, public. So if we know one of these, okay, so we know B is public. So we go to here, okay, so it could be A and B. It's not this one and it's not this one. So it's either A and B or B and D. So it doesn't even go into, so we look at B. If we know for sure B is the right answer or one of the answers, then we only need to look at A and we only need to look at D. We don't even need to worry about C. So this makes the question a little bit easier, okay? So this is a question where you have the ABC and then at the bottom you have the choices, okay? So the right answer here is B and D, constitutional law and the taxes. This same question, you really need to learn the material, could be which of the following falls within private law? Well, then the answer is for private, it's contracts and divorce. So it'd be A and C, okay? Or the question could be which of the following do not fall in the public law? Do not fall in public law, okay? Again, do not fall in public law means which ones are they in private? So same question, you just need to understand for yourself, public is big stuff, private is small, and understand that. Don't start memorizing questions. Okay, question number 2. This is a question of fill in the blank, and stare decisis will definitely be on your exam. You need to know what is stare decisis. Stare decisis is something from common law, statute law, private law, or public law. Really easy question. Sometimes you don't have to do a lot of reading. We know this is from, okay, if we were to go here in our notes, common law is where we have the precedents set by stare decisis. Common law. Question number 3, when a judge follows a former decision because the same facts exist in the case at hand, what is that principle called? Okay, again, we can look at our notes, okay, and in our notes, common law, we have precedence, we have priority, okay. This is called stare decisis, okay. Stare decisis is when a judge follows a former decision and uses that former decision to make the decision at hand. Okay, exam question 4. The definition of doctrine of stare decisis is, okay, definition. Judge using statute law. Well, the stare decisis has nothing to do with statute law. A legal right of equitable law. It's got nothing to do with equitable law. Common law are strict, rigid, and unfair. Well, we know common law are strict, rigid, but that is not the definition of stare decisis. Stare decisis is Latin for let the former decision stand. Okay, so that we could refer to our notes. I would really like you to print out our information sheet. It's about 4 pages long, and start going through all 4 pages and reading them every second day or so. So every chapter in our real estate course, every chapter is so much information. It's a very, very difficult and a challenging exam, and you have to learn it. There's no other way. You have to learn it. Just doing lots of questions is not really the solution. It's learning the material, because the exam questions can always be changed around, and you will never have the same exam questions. Okay, the word distinguishes. What was the word distinguish mean? Distinguish was something to do with where the judge is showing that the case at hand is different from the case that he's looking at, and therefore must make a different decision. Okay, so it's not follow the decision of the former case because the facts of previous case are not present. I think this is the correct answer, but let's go through the rest. Not follow the decision of former case because the facts of previous are the same. Follows the decision of former case because the facts, I would say it's number 1. And there's notes up there that tell you. Exam question 6. Of the 3 remedies of equitable law, remember what they were. What were they? Specific performance, injunction, and quantum meruit. Which one allows a judge to give a reasonable amount of money as remedy? Which one of the 3? Specific performance, injunction, quantum meruit, or damages? We know it's quantum meruit. Okay, specific performance, what was that? That was where the contract or the order is to do what the contract says. Injunction was the order to not do what it says. Quantum meruit was to pay a reasonable amount, and damages was to pay for job done plus inconvenience. Question 7. Which of the following is a possible meaning of the term common law and statute law, respectively? Okay, remember what common law was? Common law was judges, statute law was government. Okay, remember that. Okay, so in our notes here, common law and statute, it's all here. Common law was laws created by Supreme Court. No, I don't think common law was laws created by Supreme Court. I'm not even going to read more. Okay, common law. I know common law is judge. Law created by judges. This was right. Laws created by brokerage. No. Laws created by governments. No. That's the statute. Law created by judge. So it's the opposite of this one, opposite of number 4, and I believe it's number 3. Now this same question, what you need to learn from this question is, what's the order, or what is it? Common law, put it in your notes. Common law is judges. Statute law is government. Just put that. And this same question can be reworded to say, which of the following are not possible meaning of the term common law and statute? Well, which of the ones are not? It would be 1, 2, and 3. They would be not. And 1, 2, and 4. 3 is. Okay? So all of these questions, you need to learn the material instead of learn the exam question. Okay, question 8, sorry. If no statute law exists, what option is available to the judge in the BC Supreme Court? Remember what happens in BC Supreme Court. Brand new case can start there. No monetary limit, no territory restriction. Okay, or it could be an appeal from small claims. Okay, so if no statute law exists, well, what does he have? What does the judge have then? If there's no statute, it could be he could use equity or he could use common. Well, the judge may exercise both equitable and common. Okay, that's possible. The judge may exercise common. And that's true also. The judge may exercise equitable. That's true also. The judge will not have any source of law. Well, he does have 2. He has equitable or common. I would say number 1 is more correct than number 2 and 3. So the notes are here. If you understand that portion, then you'll be able to answer this question. Question number 9. Which of the following statements is true? Okay, first statement. Small Claims Court is the smallest trial court in BC. Well, I think it's true. I think this is true. Okay, an appeal from Small Claims Court is heard by the Supreme Court of Canada. Do you remember where the small claims, where does the appeal, let's go back here, where does the appeal go from small claims? Appeal goes to BC Supreme Court. Yes, this is wrong. It doesn't go to Supreme Court of Canada. Equitable remedy is available in court as a right, regardless of all persons' conduct. Well, first of all, is it a right? Equitable remedy is available in court as a right. It's not available as a right. And then the word regardless is making it even more false statement. And we're going to talk about words that make statements false. Okay? These words are called qualifiers, absolute qualifiers. Words like completely. Okay? If something is completely, we know there must be at least one item missing. So that is going to be a false statement. Always. Something, if we say it is always safe to cross the street, well, it's not always. There must be at least one or two situations where it's not safe to cross the street. So these kind of words are always are going to make the statement false. So in this case, the word regardless makes this statement also false, because it's not regardless. There are situations where it could be the opposite. So know the words like always, entirely, none, never, all, only, must be. These are kind of words that will make the statements false. So watch our video on taking exams, and that will cover this material also. So which of the following statements is true? Well, in my opinion, Small Claims Court is the smallest trial court in BC. Now, if we had word here, smallest appeal court, this would be false statement, because small claims is not an appeal court at all. What would make this statement, number 2, correct? An appeal from small claims is heard by BC Supreme Court. If it said BC Supreme Court here, this statement would be correct. Okay, so the answer is number 1. And here, let's take a look at number 4. All cases have absolute right to be heard. And do we know that? No, they do not have a right to be heard. It's the court that decides whether the Supreme Court of Canada will hear a case or not. Question 10, fill in the blank. The steps involved in a trial process. What are the steps? Okay, we know it's pleading, and the order is important too. What's first is pleading. I know first one's pleading, and the last one is the judgment. So look for, if we know the first one, let's say we know just the first one is pleading. Okay, so we know it's this one, this could be this one, or 4. We know it's 1 or 4. And what do we know about the last one? Last one is judgment. So here's pleading, here's judgment, discovery and trial. Yes, this is the right order, number 4. So here we could see, we know action isn't part of the trial. Okay, so the trial is pleading, discovery, trial, and then the judgment. Question number 11. Which of the following would be available as a course of action to the judgment creditor in enforcing the judgment? Okay, which of the following would be available as a course of action? Okay, we know execution is available. We know a person can put a charge on the property, yes. Garnishing order is available. Examination, that's also available. Okay, examination under oath is available. Garnishing is available. Execution and charge on the property is available. In my opinion, this would be all. This would be all. If we look at this, this would be all of the are available to the person. Now, if we had said which one is the most, or which one is the first step. Then the first step would be something with the examination, and that would be the first one. That would be the first step. So same question could be reworded and said to be, what is the first available course of action of the judgment creditor in enforcing the judgment? Then it would be number 3. Number 12, the 3 phases of civil resolution tribunal. What were they? They were negotiation, facilitation, and adjudication. And it's an online system. In which phase does the adjudicator make the decision which would be enforced by the courts? Which phase 1, 2, or 3? I remember it as phase 3, where the adjudicator makes the decision, and that decision is enforceable by the court. And that is the total chapter 1. What I want everybody to do after you've watched this video a few times, and watch as many parts as you like, if you go to your Real Estate Trading Services Examination Study Guide and you want to do the questions in order, on the examination, on the real examination, they do not show up in order, but at the beginning it's a good idea to study in order. If you want questions to do with common law, these are the questions for common law questions. If you want questions which work with public versus private law, these are the questions. And questions about the BC Court of Appeal, Supreme Court of Canada, small claims, court system questions, here you have. So go ahead and do these. We will have the chapter 2 video up also within a few days. After you do chapter 1 and 2, you should be easily able to handle the assignment, which is assignment number 1 from your real estate course. Thank you. Have a good day.